Welcome everyone to this third panel of the Constitution Unit's 2025 Summer Conference. The conference focuses on Labour's constitutional agenda in office, and in this session, we're looking particularly at the rule of law. My name is Veronika Fikfak. I'm a professor of human rights and international law at UCL School of Public Policy, and I'm your chair for the session. The Attorney General and the Lord Chancellor have both placed great emphasis on the government upholding the rule of law. The Attorney General said that the rule of law would be the lodestar for this government. When he was sworn in, Lord Hermer announced his plan to protect the independence of the judiciary, to promote a constitutional balance and a respectful relationship between Parliament, the executive, and the courts, and to uphold the rule of law domestically and on the international level. As he put it in his Bingham lecture, his plan was to restore our reputation as a country that upholds the rule of law at every turn. Similarly, just yesterday, the Lord Chancellor asked how states put the rule of law at the heart of her speech to the Council of Europe. In her talk, Shabana Mahmood asked how states can guarantee the rule of law in a world where public confidence in it is fraying. Focusing on the European Convention on Human Rights, she proposed that governments across Europe work together to reform the convention, a topic we will return to later. So both the Attorney General and the Lord Chancellor have made promises and have plans about how they intend to see the rule of law realized in practice. The question for us today is what that has meant in terms of government actions and policy. Has the government delivered on its aspirations? What challenges has it faced? And what more is needed to do so? We have an excellent panel to discuss all of these important questions. We've got Andy Slaughter, who is the Labour MP for Hammersmith and Chiswick. He also currently serves as the chair of the Justice Committee. Baroness Prentis of Banbury KC, who's a Conservative peer, and she served as a Conservative MP for 9 years and held a range of ministerial roles in previous governments, including as Attorney General under Rishi Sunak's government. Finally, Dr. Joelle Grogan, who's a legal academic and is a presenter of the Law Show on BBC Radio 4. Each of the speakers will make opening remarks at around 5 minutes, after which we will have some discussion among panelists. We will then open the floor to your questions. Questions will be gathered by my colleague Lisa James. If you have a question that you would like put to the panel, please write it in the Q&A function on Zoom rather than in the chat. Lisa will then select a broad range of questions and she'll read them out loud, a few at a time. If you would like your question to be asked anonymously, please indicate so when you submit the question. Finally, let me just note that the whole session, including the Q&A, is being recorded and it will be posted online on the Constitution Unit's website, our YouTube channel, and our podcast after the event. With that, let me hand over to our first speaker, Andy Slaughter. Andy, over to you.
Thank you very much, Veronika. Thank you for inviting me. I've just come to this directly from some Solicitor General's questions in the House of Commons, where Victoria and I used to sit on opposite sides of the front bench, and I was Shadow Minister and she was the Attorney General. She's since been promoted to the House of Lords and I've been relegated to the back benches, but nevertheless, the only reason I mentioned that is that about half of what was discussed was around the ECHR and around the rule of law. That's very common now. It wouldn't have been when I was first elected 20 years ago. We've seen what which I'm sure we'll talk more about as the session goes on, what the Lord Chancellor said yesterday. Now, the Lord Chancellor said very clearly yesterday that the ECHR was a shared political endeavour and that the UK is resolutely committed to it. That's not what's making the headlines. It's the qualification, as it always is, where she went on to say the trust of the public is beginning to erode as the application of rights feels out of step with common sense. And well, you've already quoted the Attorney General, who has been very firm, very clear since his appointment, and he is a distinguished human rights lawyer himself, of course, that not just that he wants the rule of law to be at the centre of what government does, but there is a task doing in restoring its reputation. As I'm going first, I probably don't need to say to this audience what we mean by the rule of law, other than to say this. Yes, there are clearly certain concepts like the absence of arbitrary power, like legal certainty, impartial dispute resolution, independent judges, which are the sine qua non of a society that is governed by the rule of law. But it underpins so much more of what we do in society. It's one of the reasons for the economic strength in the country. The fact that large corporations, even other governments, want to resolve their issues in UK courts, bring wealth, base themselves in the UK even, because they know, even if they themselves may have a suspect past, or they come from jurisdictions which are less, which have less of a tradition of the rule of law, they want certainty. They want to know that they will get fairness in the resolution of disputes. That is something that is incredibly precious, I think, to us, and something which we endanger at our peril. Now, I don't think it is endangered, but I think there's the beginning of warning signs there, in the sense that we are having to talk about it. We're not taking it for granted. Perhaps we shouldn't have taken it for granted, but that phrase underpinning keeps coming back. It's a glue. It's also something which allows other concepts, other constitutional concepts in our unwritten constitution to thrive. The main one of which, of course, is parliamentary sovereignty. And I think that's why in the past, say, 10 years, there has been concerns arising because the rule of law is now, rather than being the underpinning, is centre stage and has become a bit of an Aunt Sally itself. It becomes a target for those, perhaps on the populist right, perhaps simply people who aren't getting their own way through legal and normal means, that you attack the messenger rather than the message itself. That's what concerns me. I'm particularly concerned recently about attacks on individual judges or on the integrity of the judiciary itself. The Justice Select Committee, which I chair, has a slightly strange, I suppose, constitutional role, in that we are a scrutinizer of government. But I think we also have a role in standing up for the rule of law and in standing up for judicial independence. Judges cannot speak for themselves. They actually do quite a good job. If you look at, say, what the Lady Chief Justice or the President of the Supreme Court has done over the past year, they are not quiet in terms of what they've said, but they cannot enter the political forum, and that's why organisations like the Justice Select Committee, people like Victoria, who have been distinguished in that themselves, have to make their voices heard. The only other thing I would say, if you like, I mean, I look at the law in three parts. So I look at it as those basic underlying constitutional tenets. I look at it as the more practical side, the way that it gives strength to our economy, it gives confidence to society. It means that we have a robust civil society. It also, and I'm going to, in case you think I'm being erudite, I'm cribbing this from what Lord Reid said. You also have to look at the practicalities of it. It's important that we do not interfere with individuals' rights other than when, such as is defined by law. It's important that everyone's legal rights are clear. They can find out what those rights are. It's important that the law acts in an efficient and timely way, which it certainly isn't doing at the moment. It's important that courts are free, are impartial and free from political influence. And it's important that where people's rights are threatened, that they have reasonable access to the courts. And that's been another, since the decline of legal aid and other lapse of redress or access to justice, that is another. if those things are not in place, you can have all the best intentions that you want. You can have the law is only as good as your ability to enforce it and ability to have access to it. And that's my other concern as we go forward. Now, all of these things I'm sure are going to be addressed by this government over the coming years, but it's a formidable task. It's partly the inheritance that they had, but it's partly the financial situation the country is in. But at the end of the day, it is government's responsibility to ensure that the rule of law continues. Obviously, it is the judiciary who will enforce that. But unless you have a government which is sympathetic to that and which is prepared to itself uphold the rule of law, and that has been in question once or twice in the past few years, then we are on a slippery slope. And I'll leave it there.
Wonderful. Thank you. Victoria?
Well, I'd like to vehemently agree with most of what Andy has just said. We were old colleagues on, well, less of the old, on the Justice Select Committee for years. And I think the way that he defined the rule of law in his career has been very much focused on access to justice. And I know that that's something that he continually pushes. Is very good. I don't necessarily agree with all his political points, but otherwise, I think the definition pretty much stands. Since leaving office last July, I've watched the rule of law discussions from a slightly different context. So we talk about the rule of law, it's very well defined. Students watching can look up the various definitions over the years. I gave one as AG, which Andy has pretty much just rehearsed. The rumble in the jungle, if you like, which is what Lord Wolfson has described the current row as, is really about the extent to which international law binds, if you like, government policy in the domestic context. So that's what the current discussion about the rule of law often focuses on. Now, where I'm coming from, I think puts that in some sort of context. So I have slightly fallen into a new career as a trainer of Ukrainian lawyers. So we've been training prosecutors, judges, defenders, and even those who go in and secure the evidence, those who investigate the aftermath of a war crime in Ukraine. And I've been doing a lot of this training since I left office last July. And for me now, the rule of law has taken on a much more fundamental tone because of the work that I've been doing. So I'm a British lawyer. I'm an English lawyer. I have spent my career working in the human rights field, nearly all for the government, any government of the day. I was a civil service lawyer, specialising in MOD work for a large period of time, but not exclusively. And I'm, if you like, it's not about me, it's about our system. We are valued by the Ukrainians for what we bring to the party. We're valued as a nation that has had a rule of law for a very long time, that has a really independent and good judiciary. And this is something we really take for granted in the UK. It was interesting, before this panel started, we were chatting, and yet again, your convener said, oh yeah, it didn't really come up yesterday. The law argument didn't really come up. And you think, yeah, it never does. We bank it here. We just take it as read. And my experiences over the winter have been all about how we shouldn't bank it. We should talk about it. We should say, as Andy just did, this underpins a lot of the work of the City of London. This underpins a lot of the prosperity of the UK. And so in Ukraine, they're prepared to take really quite harsh criticism from me and other English and Welsh barrister trainers. They're prepared to accept what we tell them about their own constitution and about international law. They're prepared to do that because they value what we don't value. They value what we have. And whereas now my rule of law is viewed through a prism of, is somebody defended? Is a Russian soldier defended? Is a Russian soldier even aware of when the case against him is? Is the Ukrainian judge openly hostile to the defence? Is the Ukrainian judge prepared to put the court heating on when the defence wants to make its arguments? These are very basic issues. These are things we have taken for granted and perhaps not verbalized for too long. And while I am so proud of what the Ukrainians are doing, it's incredible what they're doing. They're prosecuting war crimes during an active war. Their lawyers are not sleeping at night because of bombs. But they nevertheless have 170,000 open files. They have prosecuted to conclusion, and international NGOs look at how it's going. They're pretty good. They stand up to international scrutiny. They have prosecuted, I think, about 171 and probably counting cases to conclusion. They're doing it well. They're defending the Russian soldiers well and properly. We should applaud this, and I think we do applaud this, but we should also be aware of our place in advising them and helping them to do that. And I think that does take back the rule of law discussion to a slightly different level. So yeah, I'm really happy to go into the rumble in the jungle. To what extent should and does human rights law apply in the UK? But actually, let's remember where other places start.
Yeah, thank you so much for that. And now turning to Joelle.
Thank you. Wouldn't it be terribly controversial if I just continued and said I entirely agree with everything that I've just heard? I'm just going to be echoing so much of it. But no, I think I'm going to try and first restrict my marks because I realize there's such an interesting wealth of conversation and debate to be had about the rule of law in the UK context. But I do want to pick up on what Victoria has just been talking about in terms of the wider rule of law context. Very briefly, we're witnessing a decline on a truly terrifying scale. I know that the statistics coming out of the World Justice Project marked 57% of countries declining in the last year, and this is a continuing trend. I know for everyone listening, they will be so cognizant of what's happening in very major international states in terms of the autocratization of the state, of the centralization of power, of dismissing, ignoring, even threatening judges in the judicial system, threatening, ignoring, taking lawsuits, or even arresting political opposition. Even as I'm describing these individual instances of what can be described as markers of rule of law decline, if not destruction, I know everyone listening will be thinking of at least 4 different countries that I could be describing. And the truth is, it's so many. So I, again, want to echo Victoria and Andy that there's so much to celebrate in the UK in terms of its adherence to the rule of law. I wish there was a more powerful way of saying taking for granted. It's almost become invisible to us. It's so integral in our systems that we don't see it. I'd also apply that to the same principles of democracy and even protection of individual liberties and rights. They are so invisible to us that we do not see the wealth that we have that is not available to so many and being taken away from so many people. However, I'm also conscious that we shouldn't sit on our laurels and just describe how wonderful the state of the rule of law is here in the UK. I do want to restrict my opening salvo to 2 brief, largely contextual points. First, talking about markers of adherence by government to rule of law. And I'd say this has the shade of 2 elements. It's 2 sides almost of the same coin, which is the importance of rhetoric, the commitment to the rule of law. We commit to the rule of law, but also a fulsome protection, a fulsome praise and, again, protection of the judiciary, of judges, not undermining these essential systems of independence and accountability. Rhetoric is important. However, I'd also say just as important as rhetoric is obviously action. And in this, one of my favorite phrases that I got from a fantastic film from about 20 years ago that I still quote is, principles are only meaningful when they are inconvenient. We can mark so many instances in the last 10 years of misuse of skeletal legislation, Henry VIII clauses, the degradation and decline of pre- and post-legislative scrutiny. We can highlight so many issues that can be improved in the context of lawmaking by government in their actions. But again, principles are only meaningful when they are inconvenient. It's always a little concerning for me. I have a little red flag raised anytime I hear any MP use the phrase emergency legislation in the context of the UK. Second, I just want to talk a little bit about public experience, the public perception of the law, the legal system, and ultimately of the rule of law in the UK. The incredible, probably undeserved privilege that I have as now a broadcaster trying to explain the law to anyone who cares to listen at 3 p.m. on a Wednesday is listening to the concerns and listening to the confusion and listening to the experience of ordinary people in the legal system. And in this context, I'd say the lack of legal aid is a travesty. The falling apart of the criminal justice system is borderline criminal in and of itself. The experience of people, of the confusion, the cost, the delay of the courts, of ordinary administration of justice, is something that is just as critical, as meaningful to the rule of law in this context as Henry VIII clauses or any discussions that we have in legislative scrutiny. The reason I highlight of the central importance of the experience of law and the legal system by the ordinary person is because I know too often in those states that I've studied, I've worked with, I've worked on, I've worked in, that as soon as the individual thinks there's no point in going to court because it's too long, it's too costly, the judges are bought, that's the point that they start trusting and believing in parties, people, and often populists who say throw out and get rid of the whole system. If individual cases are awful and terrifying, and I think of chicken nuggets here, then we should just get rid of the whole system. That'll fix things. To me, that is terrifying because I have seen the slow degradation of rule of law in other states that comes just before a precipitous disappearance of the rule of law, of democracy, of the protection of rights. So let me conclude with this little opening salvo by lauding the fantastic state of the rule of law that we're in, lauding the fact that it is currently invisible to us, but marking it shouldn't be invisible. It should never be invisible to us.
Thank you, Joelle. Thank you, Andy, and thank you, Victoria. So we'll turn to audience questions in about 5 minutes. Many thanks already for the questions that you've submitted thus far. If you haven't submitted a question yet, now is the time to do so. Again, please do so in the Q&A function on Zoom at the bottom of the screen. But before that, let me put a few questions to the panel. And I thought, given the topic of the conference, which is Labour's constitutional agenda, I wonder it would be helpful to reflect on this 1 year of Labour in power. And I wondered, and this is for each of our speakers, if you could think of a single thing that you would like to sort of talk about that the government has done thus far that has either made a major step or has been a major improvement in the area of rule of law, what would that be and what is still needed to be done? Maybe if I turn to Andy first.
Yes, thank you very much, Veronika. I think the important point, which is how I began my 5 minutes, is to listen to what those who have responsibility for safeguarding the rule of law are saying. Now, Richard Hermer has been absolutely clear in a series of speeches, as I say, that the importance of the rule of law, that it was central to the government. So is the Lord Chancellor, and so I think have all ministers with responsibility. I think that's, I don't want to make party political points, so I'll limit myself to saying this. I think we did get, we were sailing fairly close to the wind at points during particularly Boris Johnson's time as Prime Minister. And certainly the feeling was out there that the law didn't apply to everyone equally, and that some people in authority could make the law do what he wanted rather than lead rather than follow in that way. And I think that was a very dangerous path to start going down. I don't exaggerate it. I don't think, you know, we all remember Miller 1 and Miller 2 and the celebrated sort of landmarks of that period. But I do think it was very important for an incoming government, whoever they were, whichever party or coalition of parties, reasserted those rights, what the rights of Parliament were, but equally where the limitations were, as we all are subject to law, whatever our position in society and whatever our position in government. And I think that has changed, and that's the ground. Obviously, I think what we'll come on to next is where the government has failed, where the government has not upheld those principles that it has stated. I'll be very happy to say something about that now, but I think they started off by saying the right things, because this is one area where saying things is important as well as doing things. In politics, it's usually the other way around. You say a lot, you don't do very much. When you're talking about basic constitutional principles like this, it's important that you first of all assert them.
So in some sense, you're saying the rhetoric has changed. Is that right?
I think it has in a positive way, but I also think that controversy that surrounds it, which is fine because we live in a free speech and we live in an open society, but I think there is also a tendency to, particularly for people on the populist right, to have battering judges or battering legal principles or conventions is a good way to assert your case to the public.
Thank you. Victoria?
Well, I think you'd expect there to be a high level of agreement, despite political differences on this, from people who are lawyers, frankly, because I think there is a high level of agreement as to what is important. The extent to which rhetoric is helpful is quite a difficult one to get right as a minister. One thing I would gently say to Andy is, it's interesting, isn't it, that while there was definitely a huge row between the government and the Supreme Court on prorogation, for example, the fact is that the Constitution worked, the Supreme Court gave a ruling, and everybody absolutely complied with it, which is interesting in itself. I mean, the fact that nobody commented on that is of course good in rule of law terms, and we carried on. But let's not dwell on the past. Let's try and focus on the subject of the conference, which is where we are now, which is that as attorney, I tried very hard to be heard within government very loudly, but not heard outside. I made a fairly serious and not unlike Richard Hermer's speech on the rule of law that was quietly received in academic circles, but was really not going to set the world on fire. And I took that path deliberately. I've been a government lawyer. I take the view that the attorney should be very forceful in government, but perhaps best not a household name, as it were. I think something's probably gone wrong with the rule of law if the attorney has become a household name. That isn't any criticism of Richard. It's at all. It's possibly a criticism of how Richard is described, if you see what I mean. And I think it's a slippery slope, and we need to be careful, because the attorney's role is a very, very important one constitutionally. And to be heard within government, you perhaps need to keep your powder dry.
Okay, so getting the balance of being heard and not heard right is a tricky endeavor.
It's very tricky, and I think I mean, Richard, I don't think has sought a lot of this publicity. He and I have been against each other in many of the cases for which he is now criticised. I just happened to be a civil servant lawyer, so I was always on the side of the government, and he acted for the other side. He's received a lot of criticism for that. But he has also chosen to give speeches. I don't know to what extent. I think you'd have to ask him. It's not fair for me to opine on that. But what I am saying is that for the attorney to be well respected within government circles was my main priority. I needed the Prime Minister and the Cabinet to take advice from me on legal issues. That is, in my view, the priority of the Attorney General.
Okay, thank you, Victoria. Joelle?
I am deeply shocked that Victoria does not think herself a household name.
I'm definitely not a household name.
At least among lawyers.
Yeah, well, that's okay. It's fine to be. I mean, part of your role as AG is to support and promote the rule of law in the legal profession. Absolutely fine for lawyers to know who each other are, but you wouldn't want anybody else to.
I also recognize that we've covered rhetoric to a degree, and that was initially going to be my point, lauding the change in rhetoric and very much centralizing rule of law as a marker. I think it was a lodestar of government. I might take the opposite and say it's great what we're not seeing. I spent far too long standing outside the Supreme Court over a number of years trying to explain what was going on in constitutional crisis terms. So it's quite nice not to be invited to explain things like that in quite dramatic ways. But looking at what could be improved, I note that in the King's Speech, we had a very, very ambitious table of legislation. And my concern in the context of a very ambitious, large number of changes to the law is to ensure adequate scrutiny. So I'd like to see tangible, actionable commitment to, say, publishing draft bills or a real meaningful engagement with impact assessments on legislation for this very ambitious list of legislation upcoming. That would be my small hope.
Okay, so before we turn to improvements, Joelle, can I just push you on what is it you feel now doesn't need explaining and it did before?
In the context of what questions I'm asked, or in the context of
the rhetoric. So you said you used to stand in front of the Supreme Court and have to explain things. So I'm trying to, what is it now you don't need to explain it? What's self-evident?
Oh, what's self-evident? Well, actually, one of the curiosities of the Miller cases, and this is again going back so many years, was having to explain almost the basic precepts of our government. The idea of parliamentary sovereignty, having to learn to correctly pronounce prorogation was quite an experience for me initially on BBC. But even if we think more recently in the context of pronouncing the word refoulement or refoulement, depending on which media agency I was talking to, the fact that I no longer need to explain that as a basic principle of our law, of national law, but also of international law, that we do not send people to countries where they are in very serious risk of torture or death. The fact that it's not coming to a head in the Supreme Court to have to discuss whether or not we should accept evidence on the face of it, or whether or not a decision or an act of Parliament can override self-evident facts in front of us. When I say I'm keen not to talk about this, because again we can really debate and argue about what's happened before, but we should be focusing on the current government, the current legislative agenda, the current constitutional agenda. But the fact that I don't need to stand on the BBC and say Parliament is sovereign and that's what that means, government is accountable to Parliament and that's what this means, judges are independent and that's what this means. The fact that I do not have to explain these very core basic elements of constitutional law here is, to me, a great thing. My voice is quite rattly right now, and again, I'm hoping that I have the adequate gravitas of someone with a cold, but nobody needs to hear me explaining such basic precepts on the BBC all the time.
And that is due to a new approach of the government, you would say?
That, well, ideally, it's through legislation that is not pushing those boundaries in ways that haven't been pushed before. Now, I do want to very fulsomely recognize that there are incredibly difficult political decisions that have to be made about true challenges in climate, in migration, in the economy, and these are incredibly difficult choices. But these are ultimately the political choices. In fact, I don't want to open that huge debate and take over the rest, so I will pass back to the chair.
Super, thank you so much. So the other question I had is, what is the area? What are the areas where the government has missed a major opportunity, or an area where it still needs to definitely take action? What would you single out as those areas of improvement? Andy, can I turn to you again?
Yeah, I think that the most obvious, so I think that we may be getting the questions on this, is in the realm of international law, where again we've had, when going back to the AG, when he made his major speech last autumn, sort of introduction almost to how important it was going to be. A lot of that speech was about international law. I think being polite about my own government, you can say that it's been a mixed picture. So you can look at, say, what's been done in relation to the Chagos Islands, where I think you would say that they have largely followed precepts of international law. You look slightly more obscure reference, but it didn't feature much in the news. 2 weeks ago, the Foreign Secretary was in Morocco to sign a trade agreement, which is very good. But one of the things that also happened there is that for the first time in 50 years, we effectively recognized Moroccan sovereignty over Western Sahara. Now you might say, well, why is that important? I mean, that's effectively a post-colonial situation where the indigenous population have been asking for many decades for self-determination. There is now something called an autonomy plan that effectively is a degree of self-government, but under Moroccan sovereignty. I think that was that looked like an inappropriate exercise, shall we say, of the rule of law in that way. The big one for me, I'm not going to talk about Ukraine because Victoria is here, and it's not my area of expertise. But in relation to what's happened in Palestine, I think not only because there is a long association going back to Balfour, going back to Mandate Palestine there, Britain has particular responsibilities there, and I don't think that we are living up to them at the moment, that we haven't yet responded to the ICJ advisory opinion, or after almost a year. And the only conclusion that you are led to come to in these situations is it's difficult. It's difficult for either strategic defense reasons, or for trade reasons, or for other reasons of that kind. And as soon as you start putting, we don't live in a perfect world, and we need to sign a lot of trade deals, and we need to ensure the security of the country. Those are very basic tenets. But as soon as you start sacrificing doing the right thing in relation to the rule of law for other should we say, realpolitik considerations, then you're walking a narrow tightrope there. It's nothing new. Well, I think the year I came into Parliament, or the year after, was the Al Yamami deal under a Labour government, where a prosecution, I'm sure people will remember this, but in case they don't, a prosecution for fraud by the SFO against BAE, I think it was effectively stopped because it was embarrassing to the Saudi regime, and they said that they would stop intelligence cooperation if we didn't stop, and we did. So I'm not saying all this is something that's new, but I think that's the area where we are perhaps most open to accusations of double standards.
Okay, thank you very much, Victoria.
Yeah, well, I'm trying very hard here to be as neutral and as teacher-like as possible. But I think perhaps my background as a government lawyer gives me a different perspective of what the law is there to do. And if I could just take issue with some of the things that Joelle was saying, if you have a big societal problem like climate change or migration, for example, it is the government's problem to try to solve those problems. And I'm quite relaxed about the courts being used for their fundamental purpose, which is to test where the law is. And Parliament, yes, can pass new laws, and then the court can decide whether or not those fit within the structure that we have. And I'm fine with that. I think government should, when there is a real societal issue, test that law and take a risky point if necessary. And I'm quite relaxed about that. She wouldn't necessarily disagree with me. Where I think the government has failed is on 2 points that again Joelle mentioned earlier, which is that people's experience of law really has got to match the rhetoric. And if I could agree with her vehemently that if there is delay that is too long, if your rape case isn't listed until 2029, if it is difficult for you to find somebody to prosecute your case or defend your case, then that is a real problem in rule of law terms. So I think it's really important that the rhetoric matches the reality. Otherwise, we're in a mess. And 2 quick examples of that. Shabana's speech yesterday, yes, very interesting, and I think we'll come on to talk about it, and I don't necessarily disagree with her, but a lot of what she was talking about was in fact domestic law. It wasn't Strasbourg law. And some of the rhetoric around the Sentencing Council, again, does she stand up for the judiciary? To what extent does she really feel they should be independent? Again, the rhetoric has to match the reality.
Super. Thank you. Joelle, did you want to add anything to your previous?
No, I think I've covered a lot.
Wonderful. Thank you so much. So my next question is really what's been in the news the last 24 hours, and that's the Lord Chancellor's speech, major speech in the Council of Europe, where she calls on states of the Council to work together for reform of the European Convention. And she specifically talks about this in the context of criminal law and migration. She spoke about the growing perception that human rights are no longer a shield for the vulnerable, but a tool for criminals to avoid responsibility. In the speech, she called on states to preserve the convention by renewing its moral and democratic foundation, and doing so by clarifying how Article 8, which is the right to family life, operates in relation to migration rules. Now, reading her speech, I wondered what it is that's different about Labour's approach to the issue. It was different about this interpretation of the convention, given the previous criticisms and policies of previous governments. So I thought I would put that question to you. Is the current picture, given this speech, any different than what we had before? I'll turn to Victoria first, if I may.
I don't know, because I worry that in this conversation, which is a conversation I love having, this is after all my area of law, it's the area where I've spent the last 30 years, if you like. So it's a conversation I enjoy. I worry that we're not being transparent or honest with the public, if I'm honest. So a lot of what Shabana said about worrying about where human rights law is, absolutely, I agree with her. I think most of the Conservative front bench would agree with her. But where's the problem? So we haven't got a case before the Strasbourg court which disagrees with either the government or the opposition on those points at the moment. So I worry again about rhetoric and reality not being aligned, and the fact that, yes, of course, I love talking about human rights, and we ought to talk about human rights and where they are in society, but we mustn't blame the wrong thing for our perceptions as to the law getting in the way, because that is a way to really undermine courts and judges if we blame them for something they haven't yet done. So this takes me back to my government lawyer perspective, which is that, okay, if we have a view in this country with a democratically elected government on where human rights law should be on a particular issue to do with deporting migrants who've committed offences here, for example, then we make sure our domestic law is clear and accessible. We take a case through our courts, and then we see if our courts and Strasbourg are not aligned. I haven't seen that happen. And it really worries me that we are in danger of making a bogeyman in Strasbourg when that isn't necessarily the case, where we have the fewest infractions in the Strasbourg court of any nation. We are a major contributor to that court in terms of money, in terms of personnel. A lot of the lawyers who appear there are British or British trained. We had a lot to do with the creation of the court. I don't think it's perfect at all. There are a couple of decisions, the climate change decision last year, Alscaney a few years ago, a case in which I was involved, I should say, that I really don't I really don't agree with. And I really think that there is urgent need for reform on some of the issues that were raised by those cases. But let's not pretend that Strasbourg is fighting us on every issue, when a lot of the problem may be to do with the interpretation of our domestic courts, and we need to be frank about that. Otherwise, we really risk undermining judges by accident, if you like. I hope I've explained that properly. It's a difficult thing, because we're having a good conversation, but it's not about the right thing.
Yeah, thank you. Andy?
You'll have gathered by now that whenever I hear these sort of landmark speeches, I think, where have I heard that before? So I went back and looked at 2012, when Ken Clarke, then Lord Chancellor, and Dominic Grieve, then Attorney General, went to Strasbourg to sort things out, and came back and said they had sorted things out. And Ken Clarke said the changes that they had made to the way the European Court operated should mean fewer cases being considered, that it would only consider serious violations, would not normally intervene when national courts have clearly applied the convention properly. Dominic Grieve said it makes clear the primary responsibility for guaranteeing human rights rests with the government, parliament, the courts of the country, and so on and so forth. And actually, I think they probably had done that, and and what it pointed to is, if you feel that things have drifted from where they should be, you simply correct them. That is what has happened. And I'm not saying I agree with this. I'm just saying it has happened. It's happened with the Supreme Court under Lord Reid. And it's not my imagination. He said, it's not a secret. He's on the record saying that I don't think we have really judicial activism in this country, but what he has said is he's pushed back on the tendency of lower courts to challenge the government, and he's spoken up for the rights of elected ministers, seeming to correct a balance in the court there. And in a similar way, the appeal courts have looked at some judgments made by immigration tribunals or lower courts here, where they think they've taken a too rigid view of Article 8 and said, actually, no, there is flexibility in the system, and that's why it's resilient, because it can adapt to different political climates, different times, still keeping the basic principles we started talking about in terms of judicial independence and fairness and all of that, and everyone having the right to a fair trial and not trial by media or by public opinion. But all of that not only is possible, it has happened before, it is happening at the moment. And I think that's what Shabana was talking about. And I don't see a problem with that, except that there were other voices out there who really are using it as a stalking horse for other things, like withdrawal from the convention and things of that kind.
Okay, thank you very much. Joelle, would you like to add anything?
Absolutely. I think this is an area in which we sorely, and perhaps this is blasphemous to a lawyer, but we sorely need data and statistics. Right now, perception is being entirely shaped by a media narrative of cases which we don't know if they're representative of the domestic system. I can say statistically they're not representative of EU decision-making. As in the EU courts, we know that in the last 45 years, there have been 22 cases concerning, I think, the Article 8 interpretation of removals from the UK, 12 of which sided with government. 6 of the ones that sided against government concerns detention of migrants. Sorry, excuse me, detention before removal. And the last 4 focused on disproportionate impact on the individual in the context of family. So I know in the EU ECHR context, there's a very, very clear line of deference in the context of security and migration decision-making to government. However, I do want to echo what we've just heard. This doesn't mean that this is a perfect system or perfect decision-making in the UK. And I come back to what I'm struggling with right now, which is finding the figures. How many cases of deportation are being lost on Article 8 grounds? Give me that figure and make that figure public.
Yeah, thank you very much. Thank you all. We will now open for Q&A, and I'll ask Lisa to join us and to give us a few questions. Thank you.
Thank you, Veronica, and thank you to everyone in the audience who's been submitting questions. We've got some really interesting ones coming up. I'm going to start with a round of three, which all I think pick up in their different ways on things that Lord Hermer mentioned in his Bingham lecture as potential priorities for the government. So first, an anonymous questioner asks, is effective parliamentary scrutiny of ministers part of the rule of law? And if so, has the Labour government been more open than its predecessors to such scrutiny? John Cummings picks up on rhetoric, asking, the role of barristers is to ensure that defendants get a fair trial, not to decide innocence or guilt. The role of judges is to interpret laws as passed by Parliament. So do accusations about lefty lawyers or judges not undermine a fundamental principle of our legal system? I suppose implicit in that, if so, what might we do about it? And then finally, Mary Southcott picks up on calls for better public education about the rule of law, which Lord Hermer has mentioned, and I know it's also been mentioned by some independent reviews that have taken place over the years. And she specifically asks, how do and where do children and school children learn about the rule of law?
Wonderful, thank you. So if you could pick one or two from that list and address them, who'd like to go first? Victoria.
Well, I was just going to pick up is effective parliamentary scrutiny, and I was going to part of the rule of law, and I was going to talk about that from a ministerial perspective, which I think is, I certainly learned a lot as a minister. So I was taking through the some really big post-Brexit legislation, the Agriculture Act, the Fisheries Act, really big changes to the way that we enable those two sectors. And parliamentary scrutiny was really important. And I've only been in the House of Lords for a fortnight. What do I know? But I have noticed already that the level of engagement that I had as a minister with the House of Lords was enormous. I engaged with individual peers. I looked at the amendments that have been put down really carefully. I tried to work with my civil service team to find a way that would bring in the best ideas and help people to a place of some form of consensus. I've really noticed in the 2 weeks I've been in the House of Lords that the government is not working collaboratively with this end of Parliament in the way that we did then. That's partly probably because of the maths of having a large majority. So the government is able simply to dismiss amendments that have been made. But I think that's a shame because when Parliament is being its most effective is not when it's having great moral debates. It's not rhetoric. It's when it's amending law, real law, and being very careful and detailed in its scrutiny of what the outcome will be if those laws are not, to go back to the original definition or Bingham's definition of the rule of law, which is laws have to be intelligible and clear and predictable. And part of the purpose of having a House of Lords and good scrutiny in the Commons and things like Andy's excellent committee is to make sure that people who are experts in those fields really scrutinise laws. And I worry that because of the size of the majority, that's not happening.
Mm-hmm. Thank you. Andy?
Yeah, well, as I chair select committee, and they are one of the sort of, they set up with the specific intention of scrutinising government. They do other things as well, but that's probably the thing that always gets attention and does get some publicity is when there's a combative session with a minister. And I think that's good. In the same way that liaison committee, which is all the chair of select committee, does that with the prime minister. And I can remember me when I was an ordinary member of the committee some years ago, giving or trying to give Suella Braverman a hard time when she was Attorney General, and the Conservative then chair of the committee let me have a field day doing that. And so equally, when Richard Hermer came before us, and obviously I'm a Labour chair of committee, but Conservative members on the committee wanted to do the same for him. I thought, well, it's only reasonable that I let them do that. And of course, neither Suella or Richard are shrinking violets, and they were able to deal with it. But they're very robust conversations. So I would say I wouldn't sort of claim that we are part of the rule of law, perhaps, but I think it's grown in importance, the select committee system, because what it's doing, as I say, sometimes things that other bodies can't, like speaking up for the judiciary, and we certainly have done. My members and I in the chamber have spoken up. For example, during the Sentencing Council row, which I thought was unedifying, and I'm afraid there are individuals in Parliament, and indeed sometimes it's organised on a party basis, who I think go for the man rather than the ball in that way. And that's not what we try to do. We try to be tough in terms of scrutiny, but keeping it to the issues and going. And I think that gets you more result, because as Victoria was saying, you can, if you've got a witness in front of you for 2 hours, you've got the Lord Chancellor or the Prisoners Minister or whoever, you can in 2 hours drill down and find out whether there is any substance to what they would like to present, or their civil servants would prevent them. So I think all these mechanisms are right. And I think even though there is a big majority in Parliament, and there was a big majority the other way in the last Parliament, which you might think is rather damaging to democracy, but actually MPs, and I think it's partly the constituency connection. It's partly because we have so many new MPs who don't know the old rules. They don't know you're supposed to do exactly what the whip's saying. You're not allowed to. So if they get 50 letters from constituents, they want to go and tackle on benefits or what have you. They want to go and tackle the minister and say, you got this wrong. Now, when it comes down to voting, we'll see whether that actually happens. But the rebelliousness and the independent thought and having other masters than your political masters, I think is now set into the in stone as far as MPs are concerned, and I think that's a good thing.
Thank you. Joelle?
I just want to offer a few very brief remarks on public legal education, which, unsurprising to anyone, is very, very important, I think, to all of us on this call. I was recently in a nursery located in a school, and there was a poster on British values, and one of them was rule of law, which obviously stood out to me. And I was momentarily amused at the idea that these 2- and 3-year-olds would be in any way engaging with, our debates on thin or substantive or thick concepts of the rule of law. But then I did think about it, that if any one of you listening to me right now has ever come in contact with a 3-year-old, you'll know that they have a stark, if not brutal, understanding of equal and fair application of the rules. But no, on a more serious point, it's understanding law, legal system, just fairness and rules and societal expectations of interacting with government and the legal system is so important. And I know institutions like the Bingham Centre for the Rule of Law have incredible resources that are available to schools, but we fold almost back into the challenges of time and resources for schools right across the educational spectrum, that there are certain parts of the country that just don't have resources available in terms of teaching time or even money or capacity to access these resources and bring them into play. So would I like to see public legal education supported by government that promotes rule of law from the 2-year-old who knows fair application of the rules right to the 18-year-old? Yes, absolutely. But that's probably a wish quite down on the list of priorities right now.
Could I just echo that, because I mean, one thing MPs do is they spend a lot of time in schools. So I will have gone into every one of 20 or 30 primary and secondary schools, my constituency, and the rule of law is taught. It may not be even called the rule of law in a very clear and accessible way, and I think that's one of the strengths, and that again has changed for the good over a period of time. And you'll go into a primary school and they'll have the UN Charter up on the wall, and often, particularly I'm in an inner city area, and there will be, within any class of 30 kids, there will be people who come from 10 different countries with very different standards of different types of government, different procedures, and to try and use international conventions and rights to teach all of those children together to have the same standards. It really is something quite magical to behold. I think that we need to give a little shout out to teachers in doing that, because they do it rather better than lawyers do.
Thank you very much. Lisa, do we have another round?
Indeed, we do. And we'll start with a question from Katja Ziegler, who says, although rhetoric changed in the initial months of this government, there also seems to have been some more muted or conflicting rhetoric, especially in recent weeks, and mainly driven by the need to respond in some way to far-right pressures, alleged excesses of protection of rights in the context of migration, and renewed calls to leave the ECHR. So how can or could the government make the rule of law more resilient in the face of these populist challenges and the entanglement of the rule of law with the migration debate? And then an anonymous question. Joelle and Andy both talked about delivery challenges and especially the courts backlog. Last week's spending review saw a modest uplift in the justice budget, but money is clearly still very tight. So what more can realistically be done to improve the situation? And then finally, another anonymous question. Really interesting to hear about teaching in Ukraine and what the UK can be proud of about our system. What can the UK learn from other countries about the rule of law?
Excellent. Thank you very much. Victoria, would you like to go first?
Yeah, I think the rule of law is strong enough to survive the migration debate. I think that's sort of the point that I've been trying to make. So yes, it's tough, but we've got to approach things from first principles. What do we want our laws to be? What balance do we want to strike between welcoming people to the UK and managing and integrating as a society? Laws are, well, it's always very difficult to describe where law sits in that balance. Is it our master? Is it our servant? Of course, the whole point of this conversation and talking about the rule of law is that it's there. We believe in it, so we choose to abide by it. But if we're going to, which takes me back to it's fine to push the boundaries of it, but we've got to be transparent and honest with ourselves as a society when we do that, which is why it's so important that rhetoric matches reality. Can we learn from other places? Yes, of course, we can always learn from other jurisdictions, but my slight point from my Ukrainian experiences is how much they value what we take for granted. So that's an easy thing to say, but it's something that has been drummed into me daily over the course of this winter. So I think what I take from this, and it is important that we keep learning all the time as lawyers, is that the rule of law is only good if we are completely transparent and honest about what we're talking about. And I am very worried that the debate on ECHR is getting away from that.
Thank you. Andy?
Yeah, I mean, I'm not going to repeat what I said earlier about the fact that there is flexibility within the system to allow for changes in political mood, control, etc., and that's the system working as it should do. I mean, I may not like the way the thing's going, but I accept that that's because that's all within a rule of law context. I think what's happening with the far right is something very different, which is simply using dog whistle issues, whatever you want to call them, that you attacking, victimizing particular groups in society. I mean, we saw it in the terrible events in Ballymena last week, and people jumping on the bandwagon there, including far right or right wing MPs, to say that this was a failure of integration. This was a failure of this was a responsibility of a particular ethnic group in that way. And where that is happening, you want a united front from responsible politicians across the political spectrum, the mainstream political spectrum, to reassert the fact that we are a country that believes in the rule of law, that if people do things wrong, they will be punished according to law. We will not have vigilante justice. We will not have the determination that particular groups of people, ethnic groups, what have you, are going to be treated in a different way. That's the divide, and I don't see that mainstream political opinion is getting into the slipstream of that far. I don't want to be complacent about it, because it's a serious problem in that way. Can I just deal with the issue of the settlement? I'm not going to start big conversation about the spending settlement, but all I would say is that the major lawyers' organisations, Bar Council and the Law Society, welcome the settlement, the 3.1% real terms rise over the next few years, not as going the whole way, but it was certainly a much better settlement than the MOJ was expecting, and it needs to be, because there is so much interaction between the different parts of the criminal justice system, and I was talking about this in the Commons yesterday at a debate on the crime and policing bill, which is, it's great if you're going to have more police and you're going to put more money into policing. That means you arrest more people, you charge more people, you prosecute more people, you need more prosecutors, you send more people to prison, you need more prison places, you need more prison officers. And then if you're going to take, and the answer the government would give to that question is Gawk and Leveson. And if Gawk is implemented and 10,000 people who would have been in prison are now being punished in the community, that means you create more work for probation, and that means and also potentially for the police as well, because some of them will slide back into offending. So that's why the criminal justice system as a whole has to be looked at as all of a piece, and we have to improve standards across it. But I mean, at the moment, we're absolutely right to say it isn't working. It isn't working when people are waiting 2, 3, 4 years for trials, where people are on remand for years who might then be acquitted or have served longer on remand than the crime merits. And that, I worry probably more about that undermining the rule of law than anything else, because there's no justice for victims there. There's often inappropriate punishment for defendants in that way. But again, the solution, the government would say, is see what's in the Leveson review that's coming out probably next week or the week after, and that itself will produce another area of rule of law controversy when he proposes not using juries in some trials where they're now available. But it keeps us all talking, doesn't it?
Thank you very much, Joelle.
I was going to echo the comments of the Bar Council and the Law Society in terms of spending review. Obviously, there's still more to be done. But just to tackle that first question in terms of entanglement and defense of the rule of law, this shifting rhetoric, what I would say as a casual observer of the politics in other primarily EU states is you can't outright the far right. And once you allow that narrative to be captured, it's captured. You can never go as far or as extreme as will be presented as the counterpoint. What I'd really like to see is a robust celebration, if not pride, in how well the UK is doing on so many fronts, especially in the context of the ECHR. I was part of an interesting conversation recently in which it was highlighted that the fact that we have fewest applications per capita and an average of 1 violation a year for the last couple of years is actually a sign of how terribly we're doing. We should, in fact, be getting multiple violations. We should be standing up and be seen as not, that is not something that we should take pride in. The fact that we are adhering and such a standard for international norms is not something to be proud in, and that's tragic to me. So recapturing a narrative of pride and celebration in the legal system and in the protection of individual rights, to me, is a narrative worth having and worth holding, rather than falling into what you can never win, which is a space that is full of misinformation and disinformation, and currently not enough public education and public statistics.
Okay, wonderful. Thank you. So before I ask you all to join me in thanking the speakers, I just have a few bits of housekeeping. The recording of this session today will appear on the YouTube channel and on our podcast feed in the coming days. Please do subscribe to those and look out for information on our website or Twitter. If you're not already signed up to our events mailing list, please do so in order to hear first about our forthcoming events, and you follow the Get Involved link on the Constitution Unit's website. The next session of this conference will start in about 45 minutes at 1 p.m. and the topic of that panel is reforming the House of Commons, and speakers include Kat Smith, the current chair of the Procedure Committee, and Wendy Chamberlain, a member of the Modernization Committee, as well as Hannah White, the director of the Institute of Government. I hope you'll be able to join us for that. The Zoom call will end shortly, but you'll be able to join again using the same link as before, just before the next session is due to begin. With that, let me thank you all for attending today, and let me, on your behalf, as well as my behalf, thank our brilliant speakers, Mandy Slaughter, Victoria Prentis, and Joelle Grogan, as well as Lisa for fielding questions, and Ed and Rowan behind the scenes for making everything run smoothly. Goodbye for now, and we look forward to seeing you again very soon. Thank you so much for coming.